Torts. So what is a tort? A tort is a wrongful injury to a person's person or a person's property. Well, how does that differ from a crime or even a breach of contract? All of these are wrongs by one person against another, but there are different types of wrongs. So we need to understand what these are and how they're similar and more particularly how they're different. Tort, wrongful injury to a person's person or a person's property. It's a civil action. A crime is going to be what we call a criminal action. Here, we're talking about an unlawful act that's punishable by the state. Now, many torts will have a counterpart of a crime, and we'll look at that in just a moment. The object of crime is to punish these wrongful acts, and the object of tort is to compensate, for the most part, sometimes punish, for the wrongful injury, but to compensate. Breach of contract is also to compensate the wrongful act. But what is a breach of a contract? Well, that's a failure to fulfill promises that someone has made in a contract. So when we talk about torts, we are talking about these wrongful injuries to a person's person or a person's property. All torts have what we call elements, and the plaintiff must allege and prove each of the elements to establish that there was such a wrongful injury to a person's person or a person's property. The analogy I like to use is like baking cookies. A particular recipe for cookies has ingredients, and if you leave out one of the ingredients, like chocolate chip, for example, when you're baking chocolate chip cookies, you're not going to end up with chocolate chip cookies. You're going to end up with something else, maybe sugar cookies, or maybe no cookie at all, depending on what you leave out. Well, that's the same way it works with torts, that you leave out a particular element. Let's look at battery here, an unconsented, offensive, or harmful contact, intentional act. If we leave out one of these elements, like intentional act, we don't have battery. It's what you have is maybe someone bumping into someone accidentally in the elevator. That's not a battery. But if you're intentionally shove someone, well, then you have a battery. Unconsented, offensive, or harmful contact, and it's an intentional act. Now, that's an example of how the elements work. We have three categories of torts. We have intentional torts. And as you can see here, battery is an example of an intentional tort. We also have negligence. That's going to be the most common type of tort we have. And then we have a class of torts that we call strict liability torts. Intentional torts. Each of these, as I said before, has its own elements. An intentional act is a common element to all intentional torts. That's why we call them intentional torts. Here's another example. This time it's assault, an attempt to make unconsented or harmful contact. Now, on the previous board, we had the actual contact, creating a battery, making a battery. But here, it's just an attempt to have that harmful contact. And you place the victim in reasonable apprehension of their safety, and that contact that they're facing is an imminent contact. It's not going to happen later today. It's not going to happen next week or next month. It's going to happen now. So that would be assault. If you actually have a completed assault where you have the contact, what do you have? Battery. Okay. Other intentional torts: false imprisonment. Intentionally restraining someone from their liberty. Defamation, we have two torts there, slander and libel. Here you're intentionally harming someone's reputation. And if you do it orally, that's a slander. You do it in writing, that's libel. Malicious prosecution, you're wrongfully prosecuting someone for a crime with bad, malicious intent. Trespass, you have an unlawful entry onto someone's property. Conversion would be another example. That would be wrongfully depriving someone of their property permanently. All of these, or most of these, will have counterparts in crime. Conversion, for example, the criminal counterpart to that might be theft or larceny in some jurisdictions. Trespass, going to be trespass or some sort of interference with property. Defamation may or may not be a crime in some jurisdictions. So many intentional torts will have a counterpart to a crime. And so that single act that constitutes a tort of conversion may also constitute the tort of theft or larceny. Intentional torts have defenses as well. Consent. If I consent to being punched in the nose, well then there is no battery on me. If I punch someone else on the nose to defend myself, well then I haven't committed battery. I've used that force to defend myself. So I have the defense of self-defense, or maybe using that force to protect others, or maybe even property under some circumstances. I may have a privilege to use force against someone, such as if I'm a shopkeeper and I suspect someone may have stolen from me. I have a privilege to briefly detain the person to determine what the facts are. A brief detention I am privileged to do. Anything beyond a brief detaining someone would probably constitute what? False imprisonment. And then in some instances, the tortfeasor, the person allegedly committing the tort, may have made a mistake, and that mistake of some of the facts may actually negate some of the elements. Depends on the circumstances, depends on the tort. Negligence is the next category of torts. It's the most common tort that we're going to see. Any automobile accident is likely going to be negligence. A slip and fall case, boxes fall over and hurt someone on the store. A railing gives way on a stairwell and someone falls. All of these are going to be most likely negligent cases. There are 4 elements to negligence. Duty, the duty to exercise care as a reasonable person would treat others around the person, to act in a responsible way as a reasonable person would do so. And then you breach that duty is the second element by not acting as a reasonable person. I should have reasonable written all over this board, because negligence is all about failure to be reasonable. Duty breach that causes, this is the linkage here, this breach must be the legal cause, proximate cause of the damages. So we actually have to prove damages with negligence, and we express damages in terms of dollars. Now there are defenses to negligence. Contributory negligence, meaning, well, the victim, you contributed to your own injury. So we call that contributory negligence or comparative negligence. We're going to compare the relative amount of negligence assigned to the defendant, the tortfeasor, and the victim, the plaintiff. Assumption of the risk. If I go in a store and they've got an area cordoned off or warning sign saying don't come in here, there's a hazard, and I go in there and get hurt, I've assumed the risk. Statute of limitations. Most personal injury claims all personal injury claims are going to have some sort of statute of limitations they're subject to. And in Texas, for example, most personal injury claims are going to be 2 years. A 2-year statute of limitations. Defamation is going to be like a 1-year statute. In other states, it may be 3 years, or it may even be 4 years, depends on the state. Strict liability is the third area of category of torts. Here, fault is irrelevant. Misconduct is irrelevant. We don't care how careful you were. You did something that someone got hurt, and you're just strictly responsible. tortfeasor is liable just because you did something specific and someone got hurt. We don't care whether you breached some sort of standard of reasonable conduct, didn't do something as careful as it could have been done. We've got several areas where this type of theory may come into play. Animal liability. If you're injured by a wild animal that someone owns, we're not talking about wild animal out in the wild, but a wild animal that has been captured and ownership claimed over an animal by someone, and that animal hurt someone, that owner is going to be strictly liable because under the law, there's no safe way you can really keep a wild animal. Same thing may apply in various jurisdictions to domesticated animals that specific animals have shown vicious propensities. And so if the owner is on warning, on notice that their particular animal is a dangerous animal and someone gets hurt, we don't worry about whether the owner was being careful or not, whether they're at fault for anything. They're just strictly liable because their animal hurt someone. There are defenses here on all of these. Assumption of the risk. You go near a wild animal when you didn't have to. Assumption of the risk may come into play, or an owner using a domesticated animal that may be a really mean dog to use that animal as self-defense to defend their property. You may have self-defense coming into play. Abnormally dangerous activities. These are activities that are just so dangerous they can't even be done in a safe way. You can't remove all risk. Here are the elements: a high risk of substantial injury. That being careful, using reasonable care doesn't remove that risk. These activities are not commonly undertaken, and under this instance, that activity is taken in an inappropriate place, like maybe blasting. There's no safe way you can really do blasting. If a landowner needs to blast a hole in their property for some reason, if someone gets hurt because of that, they're strictly liable. Now, there may be some statutory defenses, for example, to shield certain industries like electric companies or something like that, electrical power lines, perhaps. It depends on jurisdiction. The third category of strict liability tort would be product liability cases. And here we're talking about unreasonably dangerous products that have a defect, a marketing defect, a design defect, a manufacturing defect. They're just dangerous. And if it is an unreasonably dangerous product, someone gets hurt, the maker, the seller, everybody along that supply chain who created that product or maintained it in that condition, they're going to be liable, strictly liable. Doesn't matter how careful they were, they're strictly liable. There are defenses. What if a consumer misuses a product and they get hurt? Well, that's a defense. What if the consumer sees that the product is defective, has a problem, and they go ahead anyway? Well, they've assumed the risk. Okay, that would be a defense that would work. And finally, damages. Damages are expressed in dollars. And that's the injury that has resulted from the tortfeasor's conduct. Some torts, we don't need actual harm. We don't have to prove what the dollars are, like battery or assault or defamation in some cases. Trespass, we assume, false imprisonment, we assume that there's automatic harm. Other torts, like negligence, you have to prove the damages. Some torts, like defamation, we have per se defamations where damage is automatically assumed when you attack someone's honesty or credibility, so calling them a thief or a liar. But other types of defamation, you have to prove the negligence. Types of damages that we have: compensatory damages, damages that compensate for the loss. Like pain and suffering, we would call that a general damage, or medical bills, lost wages. We would call that a special compensatory damage. Then we also have damages that punish the wrongdoer, the tortfeasor. Punitive damages, sometimes called exemplary damages. And we can have those awarded when there's a willful act or gross negligence. And those are awarded to punish the wrongdoer. And then, have you ever heard of a jury coming back with a jury verdict? We find for the plaintiff in the sum of $1. Well, the jury has said, yeah, the plaintiff's right, their rights were violated, but there really weren't any damages. So we're going to award nominal or token damages. Now, this particular nominal or token damages, that's not available for negligence, but it is perhaps for the other types of torts. And this is an overview of torts.